Hello, everyone. Welcome to LARA Live. My name is David Harns. This is Andrew Brisbo. He's the director of BMMR, Bureau of Medical Marijuana Regulation. Thank you for joining us today to discuss the advisory bulletin that went out last week. We have lots of questions that we've got to get to today, so let's get started. Andrew, first of all, do you want to just kind of discuss the advisory bulletin overall?
Mm-hmm. So we were starting to get lots of questions about the CBD issue, and as we start to get our field operations up and running and getting out into some of these facilities, it's obvious that there was some confusion about how marijuana is defined in Michigan and how what many people are calling hemp-derived products or CBD-only products factored into that. And so we wanted to make sure there was clarity on what the law says and has said in Michigan so that everyone understood how to remain compliant with the new acts, and if they're operating facilities, what steps they might need to take in order to make sure they're running a compliant operation.
So why now, though? Why did you decide to issue this at this point in time?
So we'd heard on and off questions about these issues, folks that were selling CBD, and we tried to answer them on a one-off basis, but we started getting enough of them that it was clear that we'd be better served to get broader messaging out there to make sure everyone was working from the same set of facts and had an understanding of how the law read in Michigan.
So we received many questions along the lines of this one. Since no legislation has taken place, what gives you the authority to issue this directive?
Sure. And the essence of that is we didn't issue a directive. We didn't make any decisions. It was simply intended to clarify what the law already said in Michigan. So this definition of marijuana in Michigan has been in place since 1978. It was amended in 2014 to coincide with the Industrial Hemp Research Act. But those things, though, the definition that included cannabis sativa and all the derivatives of the plant has always been part of that definition in Michigan. So this was intended to bring clarity to what the law said about what constitutes marijuana and marijuana-derived products in Michigan.
And for those who don't necessarily know this, do you set the law in this regard?
No. So we administer the Michigan Medical Marijuana Act, the Medical Marijuana Facilities Licensing Act, and both of those laws refer back to the Public Health Code for the definition of marijuana.
And the 2008 law, that was put in place by the voters.
Correct.
And then the 2016 law was passed by the legislature. You're just tasked with implementing that law and putting the rules in place to make sure that that law is in effect. Is that right?
Correct. So we implement it, we administer it, we enforce it when you look at the Medical Marijuana Facilities Licensing Act. So it's important that everyone understands what the law says and how those definitions factor into how we implement that law and how we enforce it.
Okay. For those of us for those of you who are joining us late, thank you for joining us. We're going to be trying to answer as many of your questions as we can. We have, again, 4 pages worth here, and it will probably answer most of your questions if you're commenting, on the page here. But if we don't, we will get back to you later once we have a chance to kind of look through all of the comments here. But one of the questions that I thought was a good one to start out with that we got today, I'll read it to you. It will be of great benefit to Michigan's medical marijuana patients to include CBD products in the licensing program so that there can be quality controls regarding CBD. However, a wide range of unregulated CBD products are currently being sold in unregulated outlets in Michigan. Will these unlicensed retail outlets eventually be prevented from selling these unregulated, untested CBD products? And if so, when?
So our focus right now is I'd say we're in an educational phase. We're trying to make sure there's understanding about how the law applies in Michigan with the Medical Marijuana Facilities Licensing Act, that facilities that kind of grew in the space between the 2008 Act and the 2016 Act, making sure they understand how to bring those businesses into compliance, how to get licensed. So it's important to get information out there about what the laws say, what the new rules say, and how businesses can go about entering the market in that way. When it comes to enforcement of unlicensed activity, that's really a law enforcement function. So obviously we coordinate with our law enforcement partners, but we're really focused now on getting licenses issued, ensuring patient access, and making sure businesses understand what the law says.
So this isn't the law enforcement time, but that could happen in the future.
Certainly.
A lot of questions we got, the same question in different ways. Are you going to send agents into the retail settings to confiscate these products?
So our agency is an administrative enforcement agency. Our purview starts and ends with facilities that are licensed under the Act. Any unlicensed activity is a law enforcement function.
So how are these products currently regulated? How do consumers know which products they are what they say they are?
So and I think that's part of the issue, is that these products aren't part of a regulated scheme. So how to be able to tell what is in these products, there's no oversight of that. Now there will be at the state level when it comes to regulated facilities, and will ensure that the products that they sell are tested, that they bear a label that indicates what the product consists of, and is tested through a state licensed facility as well. So we want those facilities to be able to enter this marketplace and understand what their requirements are, and ensure that those products have been appropriately tested. When it comes to what the products are, I want to go back to that definition of marijuana again.
Sure.
That it's the cannabis sativa plant and all the derivatives of that plant. It includes the resin, the flower. The only thing that's exempt from that definition are the mature stalks and oils from the seeds, or the sterilized seeds. So anything that's derived from anything that constitutes a plant under that marijuana definition, so that cannabis sativa plant, falls within this. And much of the research that we looked at showed that those are the parts of the plants that are being processed in order to derive CBD.
Okay. And we'll probably get into more detail on that one as we move through these questions here. So must Michigan retailers cease selling all CBD oil regardless of its source? Are there acceptable levels of THC that would allow them to continue selling these products? So the THC level, I think it's a common misnomer that the THC level is what constitutes the definition of marijuana. I'll go back again to that definition, that it's the derivative of the cannabis sativa plant. So that constitutes marijuana, except in those very narrow exceptions. I think where that gets confusing is the federal definition of marijuana has an exception for plants that have less than a 0.3% of THC on a dry weight basis. Michigan's incorporates that definition into the definition of industrial hemp, but that only applies to colleges, universities, or the Department of Agriculture for research projects. So when we look at the definition of marijuana in Michigan, if it's a derivative of the plant, there's no qualifier for the THC or CBD content. Anything that's derived from that cannabis sativa plant falls within that definition. So to recap, according to state law, the 0.3 THC doesn't really have anything to do on the marijuana definition. That's just used in order to define what industrial hemp is, and that needs to be done in conjunction with a research program with a university or with the state. Is that right?
Correct.
Okay. All right. Next question here. If there is a follow-up to the last question, if there is an outright ban, when can retailers expect to be able to sell CBD oil in the future? And will coming regulation allow for its sale by non-medical marijuana facilities? So again, we're not. I think we had some technical difficulties there. So we are live again, and we apologize. I'm not sure why that happened, but let's see if we're live here. Are we live? All right. Looks like we're going to wait a couple minutes here for the viewers to catch back up to us. Sorry about the technical difficulties. I don't know what happened there, but maybe let's back up because I'm not sure when we cut out there. But let's go back to will LARA be enforcing this ban by inspecting retailer premises? Right. So we inspect the facilities that are seeking licensure and those facilities that have obtained licensure. Any sort of enforcement action against unlicensed facilities that are selling marijuana products is in the purview of law enforcement. Okay. And then regarding the internet sales of CBD oil for Michigan-based retailers, is there a different answer to that? No, it really all goes back to that definition of marijuana. So anyone that is selling marijuana in Michigan needs to do so in compliance with the Medical Marijuana Facilities Licensing Act. Products that are not derived from marijuana as it's defined, so products that may be derived from the mature stalks or oil from the seeds or the sterilized seed, do not constitute marijuana and therefore aren't regulated by this law. Okay. All right, let's see here. It looks like we're good. We're live again. So let's move on to the next question. My son is diagnosed with autism spectrum disorder. I give him 3 daily doses of a hemp extract oil from a Colorado-based company with the support of his doctor and his teachers. The oil is marketed as a dietary supplement, not a medication. It's ordered online and shipped to our home. Am I committing a crime by purchasing this oil and giving it to my son? So I think it's important not to rely on how it's marketed. I think that's where a lot of the confusion has come from, that
products get marketed in different ways as being CBD, as being industrial hemp, as being hemp, and you really need to look at the legal definition in Michigan. So if it's a product that's derived from the cannabis sativa plant that doesn't come from the mature stalks or from the sterilized seeds or an oil from the seeds, then that constitutes marijuana in Michigan, and any possession or use needs to be in compliance with the Michigan Medical Marijuana Act.
So a follow-up to that question then would be, can CBD be made from those mature stalks or those sterilized seeds? Is that possible? Is that done?
So we obviously don't know the details of all the science behind it necessarily, but the information we looked at in doing research to compile the advisory bulletin would indicate, and this is through some research studies, it also corresponds with information that the FDA and DEA put out that CBD and other cannabinoids are derived from the resin of the plant, or derived. It'd be very challenging to derive enough of the cannabinoids from the mature stalks or the seeds in order to have a viable product. So I think it's just important that consumers are aware of what they're getting, and products that are purchased from facilities licensed under this new act will be required to put on the labels what's in the products, and they can have some assurance of what they're getting.
Okay, so then a question we receive many times, why is this product legal in every other state except for Michigan?
So the legality of products derived from the cannabis sativa plant are dependent largely on the laws that are in place. So Michigan's definition defines marijuana in a similar way, with subtle differences from a lot of other states, that there isn't an exception for that THC content from the definition of marijuana. It's all dependent on coming from the cannabis sativa plant. So anything that's derived from that plant that doesn't come from the stalks or the seeds is considered marijuana in Michigan by legal definition, and therefore is regulated.
Okay, so then a product that says it labels itself as marijuana CBD, is that legal to buy? Is it legal to sell? Is it legal to possess in Michigan without an MMMP card?
So the short answer is no. If you are possessing marijuana products in Michigan, then it needs to be done in compliance with the Michigan Medical Marijuana Act.
And the same is true about hemp CBD, because in Michigan it's defined as industrial hemp. Is that right?
Well, the industrial hemp definition, as we said before, only applies to colleges, universities, or the Department of Agriculture and programs for research. And there are no industrial hemp research programs authorized under that act in Michigan at this time. So possession of any product that's derived from the cannabis sativa plant and that falls within the definition of marijuana needs to be done in compliance with the law.
All right. So for business owners in Michigan, a question that we received a couple times was, is it legal for me to sell CBD products that are not grown or cultivated in Michigan? If they bring it in from outside Michigan, may they sell it here?
So any products in Michigan are subject to those legal definitions in Michigan. So selling a marijuana product as it's defined in Michigan needs to be done in compliance with the law.
And is Michigan, when the licensing and all of that is put into place, is it a closed state system, or will there be allowed to bring products in from outside to our state?
No, so the Medical Marijuana Facilities Licensing Act is in essence a closed system. So a retailer has to purchase those products from a licensed processor or grower, and has to ensure that it's been tested by a licensed safety compliance facility.
All within the state of Michigan. So all products that will be offered for sale in Michigan will have gone through the tracking system, will be tested multiple times, and will be for sale in Michigan. Is that right?
Correct.
Okay. All right. Let's see. Page 2. My supplier tells me that the product they are selling me is derived from industrial hemp, not marijuana. May I continue to sell that to the public, or may I only sell it to card holders?
So we go back to that definition again, because that term industrial hemp is thrown around to mean a lot of things. But anything that's there are no industrial hemp programs in Michigan under the Industrial Hemp Research Act. So if that product's sourced from out of state, and going back to that definition again, that if it's a marijuana product, then it can't be sourced from out of state and under these laws. And in Michigan, it needs to be produced by a licensed facility, and then those provisioning centers licensed to sell marijuana products can only sell it to patients.
Okay.
Or caregivers, I should say.
Card holders.
Correct.
Okay. Let's see. This question is very similar, so I'm guessing we'll get the same answer, but can CBD oil manufactured from the hemp plant that contains no THC be sold through a retail outlet in Michigan?
So you're right. That's a common question. It goes back to that THC again, that the definition of marijuana in Michigan isn't hinged upon having THC content. It's anything derived from cannabis sativa plant. So any sale of those products needs to be done in compliance with the law.
All right. How does the new law affect CBD product that falls under the compliant EU or the imported hemp? What about CBD made from the hemp plant that's been made legal for processing by the 2014 Farm Act? Can LARA and BMMR supersede federal law?
So the Federal Farm Act authorized states to enact legislation to have industrial hemp research programs, which Michigan did with the Industrial Hemp Research Act, but that's still very narrow in scope. So we go back to those same talking points that if it's derived from cannabis sativa and it didn't come from the stalks or the seeds, then it's regulated as marijuana. There's no distinction whether it has THC, whether the producer is calling it hemp or industrial hemp. It has to fall within that definition in Michigan. And there are no industrial hemp research programs at this point. So all those products that are derived from the cannabis sativa plant are subject to these new regulations.
So then how will this change affect online sales of CBD products derived from industrial hemp or marijuana? Will such products now only be available through face-to-face transactions at licensed provisioning centers, or will there be an online component available in Michigan?
Under the Medical Marijuana Facilities Licensing Act, these facilities will have to conduct face-to-face transactions. There's no delivery, there's no online sale.
All right. Let's see here. What do we tell our customers and patients that would like, who would like a legal and safe product but cannot get a medical card because of employment or other personal reasons? Is there a legal option for CBD in Michigan for residents that don't have a medical marijuana card?
So the Michigan Medical Marijuana Act requires a registry card in order to possess and use medicinal marijuana.
Okay. All right, let's see where we're at here. Is there a product that you can recommend or that BMMR can recommend that is derived from seeds and stalks and not from the portion of the marijuana plant that's mentioned in state law? In other words, are there products out there that are made from CBD that are derived from the seeds and the stalks, which you mentioned are exempt from the definition of marijuana?
So as a regulatory agency, we wouldn't make recommendations on products. I think when someone is seeking out products to use for medicinal purposes, that's something best done in conjunction with their physician. But I think it's important for patients and consumers to educate themselves about what the products are and ensure that they're getting what they think they're getting. And if they are being sold products that claim to be derived from the stalks or the seeds, to be able to validate that those products actually contain what it is that they're seeking for medicinal benefit. Part of the regulation of these facilities will be ensuring that the products that are sold to patients and caregivers contain the CBD, the THC, and the other elements that the patients are seeking.
Okay, and that same goes for business owners then, obviously. They need to be, as they're awaiting licensure, as they're going through this process, they need to be aware of the products that they're selling, that they are in compliance with the law.
Absolutely, and that goes back to the point of the advisory bulletin, is ensuring that everyone's on the same page as to how this is defined in Michigan and what constitutes marijuana.
All right. A question says here, I was hoping to make a hand cream with CBD in it. May I do this in Michigan? I would not have patients to sell it to. It would be sold with my product line to the general public at shows or in my store.
So if the product is utilizing marijuana derivatives or so anything as it's defined in Michigan, it would have to comply with the laws and the regulations related to this new program.
So let's read real quick what the state law defines it as. You said it's all parts of the plant, cannabis sativa L, growing or not, the seeds of that plant, the resin extracted from any part of the plant, and then every compound, manufacture, salt, derivative, mixture, or preparation of the plant or its seeds or resin. That is how state law defines marijuana.
Correct.
Okay. And that's in the advisory bulletin.
Yes.
Okay. All right, here. Another question. It says here, my client carries many lines of hemp rolling papers, and they are marketed as hemp, but do not contain actual hemp. If branded as CBD, they all fall below the 0.3% threshold for CBD, as permitted in the Federal Farm Bill Act. Can I advise my client to continue carrying these products?
So we go back to the definitions again, that there is no threshold for THC content in the definition of marijuana in Michigan. So anything that's derived from marijuana, as per that definition you just read, is regulated. as marijuana under the Medical Marijuana Facilities Licensing Act.
Okay. Kind of a specific question for members of nursing care facilities. Can you please comment on the use of CBD oil on long-term care nursing facility residents who are not MMMA card holders? What is required for these individuals and the facility to be in compliance with the state law?
So the use of anything that constitutes marijuana in Michigan needs to be done in compliance with the Michigan Medical Marijuana Act. That's what offers a patient protection from prosecution for possessing marijuana or marijuana-infused products. So that should be done in compliance with that act.
Okay. And this question, am I, without a card, able to have CBD products on my person for treating my dog?
So same answer. Possessing marijuana-derived products needs to be done in compliance with the Michigan Medical Marijuana Act.
And that's because the state law defines it as that?
Correct.
All right. I buy hemp seeds at the grocery store. Those are still okay, right?
So it depends on what they are claiming is hemp in that context. So the sterilized seeds of the cannabis sativa plant do not fall within that definition of marijuana in Michigan. But if what they're selling is a derivative of marijuana, then it needs to be done in compliance with these acts.
Okay. This is from a provisioning center or trying to become a provisioning center, look to be licensed. We learned of the new law yesterday. We're pulling the CBD products off of our shelves. What do we do with those products? That's the first question. What do they do with those products?
So they need to consult with their legal counsel about how to approach that situation. We can't tell them what to do with their products.
How do they become licensed?
So if they go to our website, there's a lot of information about how a facility can become licensed and start that process. They can either apply online through our online application process, or we have a paper application that can be submitted as well.
Okay. Are they able to continue to sell CBD to card holders?
So any sale of marijuana in Michigan at the retail level needs to be done in compliance with the Michigan Medical Marijuana Facilities Licensing Act.
And the only folks who should be selling marijuana-based products at this time are those who are currently operating with temporary authorization from their local municipality, have filed a state application. Is that right?
Those are the only folks that will have protection from potential denial for licensure when it comes time to issue licenses under the Medical Marijuana Facilities Licensing Act. Obviously, patients can still grow their own products and produce their own infused products. They can also still work with a caregiver, but that is the narrow context under which these products can be possessed and utilized.
That's a good point that you just brought up, and maybe you can clarify that a little bit. When the Facilities Licensing Act went into place in 2016, what did that do to the 2008 Act? Is it still in place? Do card holders have to change what they're doing? Or maybe you can just talk a little bit about that.
Sure. So the 2008 Act essentially remained intact. There was an amendment that allowed for marijuana-infused products under the Michigan Medical Marijuana Act, but that caregiver model, if you will, still exists. So patients can still possess their own plants. It still offers the protection for possession of usable marijuana. It still allows them to designate a caregiver to grow on their behalf and process on their behalf. So that's still in place under the 2008 Act. The 2016 Act just provided for a commercial and retail mechanism to cultivate and sell marijuana to patients and caregivers.
So if a caregiver has marijuana product and they want to process that into CBD oils, that is allowed if they are following the rules of the MMMA and they have their proper cards and all of that through the department. Is that right?
Correct.
Let's see here. The last question, and I'm pretty sure you're not going to be able to answer in too much detail, but we received it quite a bit. But what happens if the recreational marijuana initiative passes in November or is passed by the legislature here in the next few weeks?
Sure. So any changes to law we'll have to evaluate and enforce, but the ballot initiative doesn't impact the Medical Marijuana Facilities Licensing Act or the Michigan Medical Marijuana Act. So patients and caregivers will still need to comply with that. Retail facilities that are operating under this new regulatory system will need to comply with that as well. The ballot initiative, if passed or if legislation is passed that authorizes recreational use of marijuana, you'll need to look at the definitions that are contained in those acts. I believe in the ballot initiative language right now, the definition of marijuana is different and does change how the term industrial hemp is applied. So that law could be different, and every law can set its own definitions. So it'll be important to understand exactly what the law says. And obviously, if LARA plays a role in that in regulating facilities and access, then we'll evaluate that and make sure that we continue this educational campaign to make sure folks understand what they need to do to stay in compliance with the laws.
All right. So if the recreational marijuana initiative passes, there will be 3 different distinct laws on the books, and all 3 of them will kind of run along their own paths. They might intersect at some points, but it won't do anything to undo what the MMFLA has done or the MMMA.
Now as it's written now, that's correct.
Okay, sounds good. Well, I'd like to thank everybody for joining us today. This is hopefully the first of many LARA live sessions that we're going to do, and so we appreciate you tuning in. And we'll take a look through the comments here once we're done with the video, and we'll get back with some of those answers. So we appreciate you tuning in, and hope you have a great afternoon.